Legal rights. Legal rights apply to a collection of rights formulated within a government's legal structure. They are granted to the people of that specific state as privileges. Therefore, these are certain rights and privileges provided to citizens which are provided by the rules. According to the rules of the particular country, these rights are granted to the citizens of that country. In short, the freedoms granted to people by their governments are legal rights. These are freedoms, rights are thus established and upheld by the government's legal framework, which therefore ensures that the same parties may also redefine or change them. Similarly, these rights are not universal, differing from state to state, country to country, individual to individual, and even from time to time. Judicial privileges are protected under the ordinary statutes, but by amending the law, they may be changed or revoked by the legislature. If violated, these rights will be dealt with by either of the ordinary courts that contradict the other two rights. In general, an ordinary right imposes a corresponding obligation on another person, and in some circumstances, the state. But a constitutional right is a right that a citizen has against the state. Fundamental rights are protected by the executives, legislature, and judiciary from invasion. Limitations upon all the governmental authorities are related to all human rights. Laws and administrative orders are invalid and counterproductive that abridge or interfere with those rights. Our Constitution provides that the Supreme Court has the power to enforce human rights. The remedy itself, thus, is a fundamental right. This differentiates it from other rights. The defender of human rights is the Supreme Court. In addition, these human rights are not universal rights, such as the rights not to be subject to tax without the power of statutes. Article 265. The right to land, Article 300A, and the freedom to exchange, Article 301. It is not possible to waive a constitutional right. Person may waive an ordinary legal right. Fundamental rights. For a fundamental rights to exist, there must be human rights. Fundamental rights are those rights that are provided by some countries to their citizens. To enjoy these rights have a legal sanction. These rights can also be challenged in a court of law. Fundamental rights are equal to human rights, but there is a small line of difference between both fundamental rights and human rights. The basic difference is that the fundamental rights have legal sanctity and they can be challenged in court of law in case of violation, but human rights are not recognized by the law, so they can't be challenged in a court of law. The basic human rights enshrined in the Constitution of India, which are granted to all people, are fundamental rights. They are enforced on the grounds of ethnicity, faith, gender, etc. Without prejudice. Significantly, fundamental rights are enforceable by the courts, subject to certain conditions. These rights are called fundamental rights because of two reasons. They are enshrined in the Constitution, they are justifiable, they are enforceable by court. An individual may approach a court of law in the event of breach. Following are the 6 fundamental rights of Indian Constitution. What are they? First, right to equality, that is Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23 to 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 and 30. Right to constitutional remedies, Article 32.